who is an African and international relations analyst. Thank you very much for your time, Doc, and I hope you're well.
Yes, good morning to you and to your listeners.
Good morning. And I'm sure your attention has been drawn to this matter of the deportees that Ghana has accepted from the United States of America. First of all, do you think that was the right decision to make, to agree to accept these persons?
Well, I think that every country pursues its foreign policy with the main purpose of achieving a national interest. And as far as the country was concerned, there was an interest at play here that the government was seeking to pursue. And so if you look at the argument rendered by the Honorable Minister, at least in the first tranche of that negotiation, it succeeded in reversing the visa restriction that the United States placed onto the country. And I think that in that regard, you would say that Ghana was able to achieve its intended national interest. As to whether what it did was right, I think we need to look at it within the remit of the Constitution. And I think that is why democracy now claims to seeking some clarification or taking a legal action against the government, at the Supreme Court. And I think the verdict to be, the Supreme Court has agreed to, sit on the case for them to listen to the end of this month. And so we can go into the legalities, the international law and the international relations aspects of it. But as it stands now, this is the status.
Well, as far as you're concerned, as an international relations person who pays attention to international relations law, all of that, do you think the decision was justifiable?
I think if you're taking me back to the root of the question, and that is what I said. The government claims that there are a number of memorandum of understanding, and this wouldn't have been an outlier. Accepting, West African deported migrants was in the interest of good neighborliness and Pan-Africanism, because according to the government, these were ECOWAS citizens who wouldn't have needed visa to come in the country anyway. If the person were coming from Togo or Nigeria, they wouldn't have a visa on a arrangement. And so taking them from the US was something, we were doing something that we are already doing. And so that wasn't really a problem. My issue is that, and this is where it probably answers your question, the fact that you've had previous governments, right, conduct MOUs in such instances, there's a precedent, doesn't make this one right. Because if you look at the gravitas or the gravity of accepting deported migrants, and the implication it even has on the nationals of this country, the diplomatic relation between Ghana and the countries whose citizens we are accepting. We cannot be the outsider who needs more than the bereaved. And so before you accept these migrants, you needed to have had conversations and communication with the nationals, the countries that these people belong to. But you don't bring them here and then you start negotiating with them, and somewhere along the line they are put in some other country and they have to fend for themselves to get to their original country. And that's what I'm saying, that these things have to be done in a manner that is sequential, that is well organized. It borders on national security again. It is today that we are accepting people from deported West African migrants. And I've said that the Trump administration is a transactional one. Once it realizes that there are a number of things that you need from them, then it has an avenue to exploit you to achieve his domestic, politics. And so once it gives you domestic, West African deported migrant, tomorrow it might be migrant from other places. And that is why recently the people were mooting or thinking the idea that Abrego Garcia, for instance, was going to be sent to the country before immediately the Honorable Minister swiftly moved to debunk that news as misleading. But one of the Trump administration, and I keep saying that, look, there is going to be what you call the midterm election in the U.S. in next year November. The Trump administration needs to prove something to the people that, look, I made promises to reduce illegal immigration significantly. and this is what I'm doing. And so once it has realized that Ghana wants US to remove the 15% tariffs from Ghana, probably create a waiver for the Millennium Challenge Compact, which is bringing almost $500 million into the country, probably do something about USA. Then the owners of the elephant in the room question is, what is Ghana ready to offer the US? And that is where the US begins to pull the strings of forcing Ghana or wanting Ghana to accept these deported migrants. And then again, look, the opposition is supposed to provide a constructive criticism of the government. Look, I am happy that the government of the day was able to review or make the US change its position on the 5 years visa restriction that it changed from 3 months to single entry. It's a win for Ghana. But going forward, we should make sure that the imperatives of the 1992 Constitution, this is my opinion, must be really respected. We don't want to set a legal precedent that successive government can act with impunity, flagrant disregard to our Constitution. And why do I say that? We have Article 75 of the UN Charter. That tells us that international treaty, regardless of its forms, and if you look at the Vienna Convention of the Law today, it tells you what really we mean by a treaty. MOUs in spirit and in form, right, constitute a treaty. And our Constitution enshrines that when such agreements have been made, whether it's a gentleman's agreement or MOU, it needs parliamentary approval. Ghana is what we call a dual state. For a dual state, when international agreement has been made on the international scene, it needs to go through a process of what we call domestication in Parliament. So it becomes a legislative instrument. That's one obvious word for democratic practices and democratic ethics. In fact, if you look at Article 73 of the 1982 Constitution, it even tells you that in the conduct of Ghana's international affairs, it must be within the remit of international law. And then again, you move to Article 40 of the 1982 Constitution. The remit of Ghana's international law is its subscription to, for instance, ECOWAS laws, AU laws, including the Convention on Torture, the Convention on Refugees, what we call non-refoulement, right, which says that when a people cannot be sent to their respective countries because they feel they are threatened or they cannot be guaranteed enough security. And so if you are bringing this deported West African migrants and sending them to places where they think they are not safe, then you are violating international law. These are some of the grounds on which, for instance, democracy has a certain clarification of the issue of the Supreme Court. I think that, and this is my opinion once again, I think that going forward, I mean, if Ghanaians were quiet on the first batch of 11 deported West African migrants, and here we have accepted another 44, I stand to be corrected. I think going forward, in the interest of international law, in the taste of our Constitution, I think that some frank, open conversation has to be had about these things, in Parliament. If you ask me.
So two things. You said you think that we've put ourselves in quite a weak position when it comes to the Trump administration. They can always come back to us, maybe offer us something or offer us some reprieve, and insist that we take some more of these deportees.
Yes, because we are also wanting to pursue our foreign policy with the aim of achieving our national interest. And I have said that the Trump administration is a transactional, pragmatic government. And this is again the style of President Trump from the home. What he does is that he wants the apple in the apple farm, but he seeks down the whole farm just so when he gets you, he can wind you down to the very apple that you want. And this has been when you know how to deal with him, you can get your way around him. It's a purely transactional government. Maybe there are other things we can bring on board, but anything he does has to be seen as solving the campaign message that he promises people. So once he has realized that Ghana has a lot of demands to make from the U.S., and he can exploit that to the benefit of his domestic politics, he can go ahead.
But what choice did we have anyway?
Well, that is relevant for you in international relations. the weak can really accept what the powerful, will demand. I think, in my opinion, I think that we are bargaining from. I mean, we can stand our ground, and I like the Honorable Minister Okudoto Blackman in the times. I mean, under the presidency of President Mahama. I think that they are moving away from political correctness, in diplomacy and speaking to power. But at the end of the day, I keep saying that when somebody has a lot of resources at play, you might have your say, but if you don't have the ability to maintain their ground, they will have their.
What would you propose? And this is to land on this conversation. What would you propose the government does the next time this kind of offer is made to them? No matter the trade-off.
That's an interesting question. Well, I think that look, something ought to give in international politics, right? Something ought to give. We must always be on the position to be able to want to offer something, But you must make sure, and that is why for me, I say that we need to have a parliamentary treaty conversation about this thing. And the current government has the majority in parliament anyway. So when these things go in parliament, I am trying to identify the difficulty here. I think that we must really negotiate what we are getting out of our transaction with them. Maybe going forward, we might accept that is within the remit of international law and in the interest of Ghana's constitution. If it's submitted before parliamentary approval, we want to make sure that if we are doing anything of that sort, we are getting minimum benefit. We are getting more than what we are getting from it now. It might not be monetary value. Sometimes the non-monetary value carry a lot of weight than even financial, benefit. Maybe there are other grounds on which we can negotiate. We have so many bilateral military agreements with the U.S. There are a few cards there and there that we can do. But like I said, everything the Trump administration is doing now is inuring to the benefits of the domestic politics of the U.S. And I always say this with the next year, mid-year November elections, in mind. So I think that the parliamentary approval is a conversation that we need to have so we can appreciate what is in for Ghana and probably negotiate for more if we are going ahead with these arrangements.
Doc, thank you. Thank you very much.
You're welcome.
Dr. Roland Nanaya Omreko is African and International Relations Analyst. Very interesting analysis, some good education. Was talking about the need to always ensure that we have a clear interest in mind. In fact, Article 40 of the Constitution says, in its dealings with other nations, the government shall A. promote and protect the interests of Ghana. B. Seek the establishment of a just and equitable international economic and social order. C. Promote respect for international law, treaty obligations, and the settlement of international disputes by peaceful means. D. Adhere to the principles enshrined in, or as the case may be, the aims and ideals of the Charter of the United Nations, the Charter of the Organization of African Unity, the Commonwealth, the Treaty of Economic Community of West African States, any other international organization of which Ghana is a member. They say international relations is quite a slippery ground. You have to always be very, very careful. Let's speak to Alhaji Nusa Hussaini. Alhaji, thank you very much for your time.